SJC-10974, Commonwealth v. Michael Riley.
Good morning. My name is...
Hold on for a
Sorry.
Hey, Mr. Shedd.
Good morning. My name is Dennis Shedd. I'm representing Michael Riley. Riley was convicted of first-degree murder by extreme atrocity and cruelty, and the Commonwealth's argument was that he maliciously failed to get medical care for his daughter and ordered his wife to give her a massive overdose of clonidine, one of her psychiatric meds. Now, trial counsel failed to investigate the reliability of the overdose theory. The prosecution's argument here was that Rebecca died because Carolyn, at Michael's direction, gave 10 pills to her that night, all at once. Now, the evidence on which that is based was that first, the recommended maximum serum level of clonidine is 4.5 nanograms per milliliter. Rebecca's postmortem femoral whole blood level was 12 nanograms per milliliter, and a toxicologist calculated that it would have taken 10.5 pills given all at once to reach that level, and that's 3 times her daily dose. Now, based on Michael's statements, which the jury likely wouldn't consider too reliable, counsel argued that Carolyn only gave an extra half tablet that night, but he didn't present any expert evidence to rebut the Commonwealth's calculations that it would have taken 10 pills to reach the level that was found. Instead, he presented a pathologist who testified that the 12 nanogram level is too low to cause death, and that in fact Rebecca died of pneumonia.
And Rebecca was how old? 3 years old?
Rebecca was a little bit over 4 years old at the time, Your Honor. So that defense challenges causation, but it almost concedes malice because it accepts that 10 pills were stuffed in this girl's mouth that night. Now, the Commonwealth takes...
Well, that's... You mean because that's the only way she could have gotten up to 12? Except that there was evidence about that the 12 itself was probably elevated beyond what it actually was, right?
Well, the evidence was that there's issues with postmortem redistribution, but the toxicologist testified that's an issue into the heart blood, but as to the femoral blood, which is where the 12 came from, that's something that's fair to use for these calculations. That's what the testimony was. And that one toxicologist, Dr. Bohanek, specifically calculated, he was asked, assuming this volume of distribution, and how many pills would it take to get that level she was at, 12 nanograms? He says it would have taken 10.5 pills. So the Commonwealth argues that because counsel presented an alternative cause of death, that shows that he conducted an adequate investigation. But counsel readily admits that he did not investigate the reliability of the toxicology evidence, even though documents from toxicologists have been produced in discovery that highlighted problems with that theory. And in fact, he didn't even review the testimony of the 4 toxicologists who testified at Carolyn's trial. Now, certainly, had he investigated...
But wouldn't the investigation have essentially bolstered the idea that the defendant was pumping up this 4-year-old child with drugs?
No, it wouldn't. It would not, Your Honor. Had he investigated, he would have found a number of things. And some of this came out at Carolyn's trial. First, he would have found out that serum levels of drugs are different from whole blood levels, and they cannot be directly compared, as the prosecutor did here when he compared Rebecca's postmortem femoral level, which is a whole blood level, to the therapeutic level, which is a serum level. Secondly, one of the factors in this calculation is the volume of distribution. And while the typical range in adults has been measured, and that's understood, the range in children is unknown. And third point is that because of postmortem redistribution and other factors, blood levels after death are not the same as blood levels before death. And in fact, postmortem femoral levels for a variety of drugs have been shown to be consistently higher than antemortem levels, as much as 11 times higher.
Wasn't there evidence as to that? I mean, maybe not 11 times higher, but there was evidence that they were higher.
No, there was not, Your Honor. There was no evidence as to that. That's evidence that came out in studies that I discovered as part of producing the motion for a new trial. There was no evidence of that at this trial.
Now, at Carolyn's trial, I gather this all came in.
Some of it, at Carolyn's trial, certainly, these studies showing that postmortem femur levels are consistently higher, that specific thing did not come in. But at Carolyn's trial, the difference between serum and whole blood levels came in, the issue of the volume of distribution came in, and certainly the toxicologist there that called for the defense testified that you cannot rely on a postmortem femoral level to do any calculations about the situation before death because of all these issues. That came out at Carolyn's trial.
She was convicted.
She was convicted,
And I
yes,
gather
of
that
second degree.
Dr. Behonik's email came out at Carolyn's
trial, yes.
but not at this trial.
Not at this trial,
Now,
that's right.
Was there, the severance of the case, how soon before trial did that occur?
That happened on the eve of trial. There's actually, I believe there's a hearing on January 11th, and at that point, they think they're going forward together. If there's issues as far as paring down their statements to avoid any Bruton problems. And the next day, on the day the trial is scheduled to start, the Commonwealth comes in and says, we've decided to just go forward with Carolyn.
Didn't Carolyn actually move to sever?
There had been a motion to sever, as I recall, and then they were trying to work out the Bruton issues to resolve that.
But I mean, it wasn't
And
the
but that
Commonwealth
wasn't-
on its own, was I thought it was Carolyn's motion that got. I mean, maybe there was an agreement, but it wasn't the Commonwealth initiating the request to sever. I don't think, was it?
Well, it was the Commonwealth's, as I say, on the eve of trial, the parties were trying to pare down the statement to avoid that problem.
Right.
And so that's what everybody was working towards then. And on the day it was scheduled to start, the district attorney said, we've decided to do them separately. To avoid
Carolyn's
this whole
Carolyn's trial went first.
Yes.
She was convicted. How much later did the defendant's trial start?
It was a little over 2 months.
And was there any evidence in the record as to whether this was going to be a joint defense and Carolyn's lawyer was going to take the lead on the expert testimony?
Well, certainly it was Carolyn's lawyer who had filed some motions on that, and I guess he had taken care of retaining the toxicologist. So there may have been some understanding to that effect between them. There's no evidence of that specifically.
Did the toxicologist that testified in Michael's trial also testify in Carolyn's?
Yes, the only toxicologists who testified at Michael's trial were the two who testified for the Commonwealth.
I'm sorry, Dr. R begins with an A.
Arden, yeah,
Arden.
He's a pathologist.
Did he testify at both trials?
I believe he did.
So called by the defense, right?
Yes, he was called by the defense.
Now,
that's right.
at Carolyn's trial, was there any change in the closing argument as to the reliance upon the 12 nanograms post-mortem femoral blood level? I mean, did the Commonwealth essentially back away from that at Carolyn's trial?
To be honest, I haven't looked at Carolyn's closing argument in some time, so I don't want to guess right now. I'm really just.
I'm trying to understand. I mean, basically, what you're saying is that what Michael's attorney should have done is largely what Carolyn's attorney did do, and the question is, did that have consequence in terms of in terms of the evaluation of the importance of that reading of 12 post-mortem?
Yeah, I mean, he should have done, the point is that he should have done what Carolyn did, and there's more even beyond that could have been done. And that's to show that studies have looked specifically at post-mortem femoral levels and found they're consistently higher than ante-mortem levels. That did not come out at Carolyn's trial. And that, in fact, they've been found in some cases to be substantially higher, as much as 11 times higher. And if that were the case, then Rebecca's level before death could have been well within the therapeutic range. And what this means is basically the postmortem level certainly tells you she had taken clonidine, but it doesn't tell you how many pills she'd taken. And if counsel had investigated, he could have presented this at a Lanigan hearing in an effort to prevent the Commonwealth from presenting its unreliable theory to the jury. And at the very least, he could have used it at trial to challenge its reliability there.
I've forgotten. When were these studies done and published?
I believe one of them that I found, the Cook study, I think, is in the early 2000s. The Ferner study, I think, is around 2006, 2008, something like that. That's sort of a meta-study. It surveys a variety of studies in the field. But they certainly both predate this trial. And there's certainly no dispute as to the fact that postmortem redistribution into heart blood is greater than it is into femoral blood. But again, these studies show even femoral levels are higher than the antemortem levels. Now, the Commonwealth has argued that, well, these studies didn't specifically cite clonidine. And I kind of think of that as sort of as if you had an emergency except for the warrant requirement case, and you said, well, you haven't cited any cases involving a clonidine overdose. I mean, the emergency exception is a general principle that applies to any number of situations an officer could face. And given all the numbers of possibilities, you can't expect to find a court decision on each one. And this is similar. Postmortem redistribution is a function of how the body behaves as it breaks down over death. It's not specific to one or two drugs. And given the vast number of drugs out there, you can't expect to find a study to examine each and every one of those. So it wouldn't make any sense for an attorney investigating this to look only for studies involving clonidine. And the other point I want to make on that is that in the circumstances, that argument's really unfair, because what happened here is I filed a motion for funds to get a toxicologist to investigate this further. Initially, the judge allowed that motion, but when the
This is post-trial.
This is post-trial, yes, Your Honor. Initially he allows it, but a couple of days later, I guess they must have crossed in the mail, the Commonwealth filed an opposition. He then changed his mind. So having blocked me from doing any further investigation, the Commonwealth shouldn't be permitted now to come in and say, the evidence you've presented isn't sufficiently specific to clonidine.
You know, did the studies that you cited indicate that the results were only applicable to certain classes of drugs, or was it silent as to that?
Well, what they said, first, this is somewhat of a difficult thing to study. You've got to find a case where there's an autopsy done, so you've got a postmortem sample, and you've got to find cases where simultaneously they had a blood sample taken shortly before death. So they found some cases, the study I cited found some situation where that was the case, and they've had about, I think it's about 11 drugs, something like that, that they were able to look at. And they did say that, so for these drugs, they say, here's the results we found. And they did say there may be a very rough correlation between the ratio of postmortem heart blood to postmortem femoral blood and the ratio of postmortem femoral to antemortem levels. There could be a rough correlation there. Now, if that rough correlation holds, we know there's got to be a fairly substantial difference here, because we know heart blood was 19 nanograms, femoral blood was 12. It's a pretty substantial difference. So if that rough correlation holds here, you'd expect a similar difference postmortem to antemortem. But again, they had a limited number of drugs. And I believe the Ferner study cited some other studies that had done some similar testing, which I couldn't find. And again, this is part of the reason I wanted funds. You know, I was able to use Google Scholar to find some search, but some journals make their articles freely available, others don't. So there are studies I was interested in looking at I couldn't look at. That's part of the reason I wanted to get these funds.
I'm sorry to go back to Carolyn's trial, but you said the pathologist testified the same. So was the defense there also that she actually died of this fast-moving pneumonia and that clonidine did not have anything to do with it?
There was but there was much more extensive evidence there about the fact that you cannot rely on these calculations the Commonwealth's relying on. It's not only pneumonia as a cause of death, but also this overdose theory is not supported. It's an unreliable theory for these reasons. And that's the part that didn't come out in Michael's trial. And the point I'm making is also that evidence even above and beyond stronger than was presented at Carolyn's trial could have come out.
I got that part.
Okay.
Now, apart from the substantial evidence that far too much clonidine was given over the course of time, what was the evidence apart from the post-femoral blood that 10 pills were given just before she died?
Okay. Yeah, so if you assume the Commonwealth's theory was unreliable, the remaining evidence shows that Carolyn gave Rebecca one extra pill at 10 o'clock that night, and there's no evidence that Michael suggested or knew about that, and she gave another half pill 3 hours later, about 1 o'clock in the morning. And I think it's far-fetched to believe a jury looking at that evidence alone would find that sufficient to find malice. But that's the evidence, one extra pill at 10 and another one at 1,
so
another half pill 3 hours later.
Your claim is that that part of the Commonwealth's theory, which rests on a killer dose being given, rests entirely on the post-femoral blood.
Exactly. Exactly. There's certainly evidence of overuse in the time leading up, in the month leading up, that Carolyn was given more than she should have given. And there's evidence of some extra on that last night. But without the toxicology evidence, there's nothing to support a claim that 10 pills were stuffed in that girl's mouth that morning.
Well, apart from that morning, what about earlier in the day?
There's no evidence that she got any. The evidence is that basically she got what she was prescribed earlier in the day, nothing beyond that. She was getting the clonidine and the Depakote, and I think she was supposed to take a Seroquel also. She couldn't take, she was unable to take the Seroquel pills that evening, but there's no evidence of any clonidine beyond the prescribed amount earlier that day.
So what was the total number of clonidine pills that she had taken that day, at least according to the evidence?
Well, if it depends if you want the evidence as presented by the Commonwealth, or if you discount the overdose.
No, what was presented?
Actual pills.
She had 3.5 pills, plus 1 pill at 10 o'clock, and then the dispute is what happened at 1 a.m.
And that's all clonidine?
This is only the clonidine that I'm talking about.
3.5 plus 1.5 at the most?
If you discredit the Commonwealth's overdose calculations. The dispute comes at 1 a.m. Is it half a pill or 10.5 pills?
No. But what was the amount of clonidine that was prescribed?
3.5 pills.
So arguably, the Commonwealth could have argued she had 3.5 pills plus 1.5 pills that day.
Right.
For a total of 5 pills.
Right, that's right.
Which does not get to the level of 10. What was it, 10 to 12?
Well, again, their argument was that they stuffed 10 pills in her mouth at 1 a.m. She had the 3.5 earlier. She got 1 at 10 o'clock and another 10 at 1 o'clock, at 1 a.m. That was the Commonwealth's case.
Okay.
Let's see, in the short time remaining, so the Commonwealth's other theory besides overdose is that the Rileys violated their duty to get medical care for Rebecca. And as I've argued in my brief, the Commonwealth, in his closing argument, defense counsel didn't point out the evidence that would have best supported his claim that a reasonable person would not have known there was a plain and strong likelihood of death. Namely, Kelly Williams testified that although she thought Rebecca had to go to the emergency room that night, she never thought that there was a risk of death. And the experts who testified, although they said eventually, at first it would have looked like a cold, but eventually a layperson should have recognized a need for medical care, they never said that a layperson would have recognized there's a serious, serious risk of death here. That just didn't come in. Now, in a lot of cases, this court has said that improperly admitted evidence isn't prejudicial if it's only mentioned once in the course of a long trial. And this case presents the flip side of that. Here, Kelly Williams gave very important testimony in the middle of this long trial, and the concern is that unless counsel mentioned it in closing, the jurors either wouldn't remember it or wouldn't recognize its importance. And as to the testimony, as to what the experts didn't say at trial, it's very unlikely the jurors would have recognized the significance of that unless counsel said something about it. That's not the kind of thing that they're going to pick up on their own, likely.
Can you turn to the parental duty instruction? I wasn't entirely clear as to what your argument was, that
Sure.
was either error or that it somehow affected the extreme atrocity or cruelty finding.
Well, it's error which did affect the extreme.
But I didn't
Yeah,
quite, I don't
try
get
and explain
that.
I'll try and explain that. So rather than instructing that the violation of a duty of care is an element the Commonwealth has to prove in the case of a death allegedly caused by a failure to act, the judge instructed that it's a factor to be considered in determining whether the Commonwealth has proven every other element of the crime. And my point here is that as to the extreme atrocity element, he's instructing you can consider this as a factor on this violation of a duty as a factor on every one of the Canine factors. And I sort of liken this to the situation the Supreme Court had in Ulster County v. Allen, which is at 442 U.S. 140. And there the court said that a permissive inference violates due process unless the inferred fact follows by a preponderance from the proven fact. There's got to be a rational connection between the two. Now, this case doesn't, I agree, this doesn't involve a permissive inference, but the point is that the judge instructed the jury to consider the violation of a duty on every one of the Canine factors, even though it's irrelevant to many of
But
those
he didn't mention
factors.
Kineen factors, he just said any element.
Any one of the Kineen factors. It's
Now, wait, is
irrelevant.
that- Where in your brief is that? I remembered it as more on elements. I didn't remember it on specifically the Canine factors, but where is it that you have it in your brief?
See if I can spot that quickly. Starts at page 68, Your Honor.
Thank you.
It's in 68 to 72, it looks like. I have the parental responsibility issue. So he's told the jury that they consider the violation of a duty of care when they evaluate the Kineen factors in effect. And given that with many of those factors, there's really no relationship between the violation of the duty and the factor in question. To the point, given that, the instruction was the jury could have been considering this and basically says, okay, here's something in favor of finding this Kineen factor that has no bearing on it in reality. So given that it was an improper instruction that could have affected the jury's evaluation of evaluating extreme atrocity, and that's the only basis on which he was convicted of first-degree murder. And it looks like I'm over time now.
Good morning. If it please the court, Gail McKenna, Assistant District Attorney for the Commonwealth. To clear up an error right away, the prosecutor never argued that 10 pills were put down Rebecca Riley's throat. It's also important to start, too, with the fact that there was...
Can I just ask you, was that, may not have argued that in closing argument, but was that the theory that 10 were put down at that hour? I mean, was it that focused?
No. What happened, and I do want to point out, too, there was a new trial motion, and there's a decision by a judge
Right,
here.
I've read that.
That it's important to point out because that's not been mentioned at all yet. And a judge here found that what John Darrell did here, defense counsel, his strategies were quite effective. He went right to the jugular of the Commonwealth's case in saying that, look, cause of death is something completely different. It was natural. It was a natural death. But let's talk about the toxicology and what the evidence was. What happened here, and the appeals court did a great job in the Carolyn Riley case in describing it. We put forth a potential range of pills that could have been given to her that night. And in closing, the prosecutor went to a lower part of the range, which was the potential of 7 pills.
Sorry, 7 pills given to her at 1 a.m.?
The potential that could have happened.
And
If her
how did you get
entire-
there?
Sorry?
How did you get there?
Let me talk about that. We had evidence that the amount of clonidine in her blood was at 19, I think it's nanograms.
Her heart blood.
Her heart blood, I'm sorry. The femoral blood was 12. So what we did is we asked our toxicologists, and the toxicologists at Carolyn's trial also did forward-based calculations, not back calculations. Again, this is described in the Carolyn Riley decisions. And what they said is, if she was given 3.5 pills, her entire daily dosage at once, her reading should be within a certain level. Even if that was doubled, it should be 8 to 14. So that's where we came out with these ranges. And it was very clear to the jury that these were ranges. It was an estimate.
But, sorry, go ahead.
No, you go.
But the fact that you argued 7 suggests
Sure.
that the range was 8 to 14.
Well, and potentially it was.
Well, you had to have more than potentially. You had to have evidence that it indeed was between 8 and 14, which rests on the 12 for the femoral level, correct?
Well, it rested on a lot more than that. It also rested on all of the physical manifestations of drug overdose that was seen at the scene. I mean, this wasn't just a science/toxicology case. There was a lot more going on here, and that's another good reason that John Darrell didn't just present a couple of toxicologists and sit down. That's why he presented another completely different cause of death here. We had pulmonary edema, which is a quintessential sign of drug overdose. We had people in the house that were making observations of symptoms that were quintessential signs of drug overdose. We had people that saw Carolyn Riley at the defendant's insistence, no matter what the time of day was, reach in her pocketbook, take out a pill, and give her full pills, although she was prescribed only half pills. We saw overdosing going on for a period of probably 2 years before the death took place. So we constantly had the pill, had this going on. The other thing that we had was, we had the bottle of pills that had very few pills left in it, and we had Michael Riley saying, wait, both girls used the same prescription. That's why there's not enough pills in that bottle. We had Michael Riley at the scene grabbing at that bottle twice, trying to take it away from the police officer that held it, to the point where the police officer had to tell him to go sit down. So we have a lot of circumstantial evidence, along with the range of toxicology evidence, to say that lots of pills were put in that girl's mouth that night. We also have Michael's admissions that he was annoyed, that he wanted to go to sleep, and that he told Carolyn to give medicine to Rebecca that night. So we have robust evidence about the drug overdosing and intoxication with the drugs that night. In addition, we have cold medicines, triaminic strips, and we have the dexamethorphan that was also found in her system that was quite high.
But well, I'm not sure. Do you concede that there's a difference in terms of intent, not in terms of whether she died by overdose, between giving her too many pills over the course, say, of a month before she died versus giving her 7 or 10 pills at 1 a.m.?
Well, we know that the pills were given that night because of the more extreme symptomology that was seen that night. We saw the symptomology develop beginning on Saturday night, when it was first mentioned that she should go to the emergency room. And we saw that develop. And Monday night was the particularly annoying night for Michael, where he hadn't gotten any sleep. So he was very annoyed. Tuesday night was the night he was going to sleep. They went out that night and they bought 3 or 4 different kinds of cold medicines, and they had their handy bottle of clonidine. So between the clonidine and the cold medicines, we have the amount of 12 in the femoral blood. We have the testimony from the forward-based testimony from the toxicologist that said, look if you take her entire dosage and you give it all at once, what's the result that you would expect? What's the range that you would expect? What are the number of pills that would get you there? These are the number of pills that would get you there. So we had good firm evidence on that. The jury also understood, though, that we were talking about ranges, and the range could have gone as high as 14 pills, and we didn't argue that high range. We stayed at 7. There was no mention of 10. I don't know where that comes from.
Could I ask you this? Was there evidence of the difference between whole blood and serum testing?
No. Well, it was explored through some questioning in Carolyn's trial. It went nowhere. I have to talk about these articles. They have nothing to do with clonidine. We had 2 trials here, and I have to say that all of the Carolyn Riley transcripts are part of this case. They were submitted along with the new trial motion. The Carolyn Riley brief was, the grand jury minutes were. We had extensive testimony about all the studies that have been done as far as children ingesting clonidine. We had a toxicologist, pediatrician from Children's Hospital talk about the clinical observations. We had, at Carolyn's trial, the director of the NMS lab that did the work, and he was asked about the difference.
But one of the things that comes out in that email, for example, is
Sure.
Bohanek saying that there, at least I think this is what there's a, it's either about adults and children. Is that what the email? It makes a distinction that it sounded like he testified very differently in this trial from what he had said in that email. So not having that email in terms of
okay, let me talk about the email because this is important. What Dr. Bohanek is talking about in that email is written before the femoral blood even comes back. very preliminary, hadn't done his research. He's talking about the things that he needs to figure out. So, you know, it's brainstorming. He also, what he's saying in that email is, look, we're not going to do back calculations. At Carolyn Riley's trial,
I mean, retrograde analysis kind of stuff. We're not
Sorry?
doing retrograde analysis kind of stuff. We're not doing that. Is that what you mean?
right, we're not doing that. And he was cross-examined with that at Carolyn Riley's trial. It was available to use at Michael Riley's trial, but it was preliminary. He testified the same way at Carolyn Riley's trial as at Michael Riley's trial. So you take something that, you know, look at the date of it. It's before the results are final. He's saying in the email also, I have to get out there and do my research. At trial, we know that he talked to Dr. Wasserman, who was one of the doctors who was most educated about, had done a lot of clonidine studies. He'd reached out, he'd done his research, he'd talked to people, so it's a different and more educated toxicologist testifying at trial than the one that writes this email, you know, who's talking about the things that he needs to do so that he's knowledgeable about the case.
I don't get your argument that he's not back, what was the term, that he's not using the post-femoral to determine how many pills were
yeah,
given.
this is important. Back calculations are based on, we found X amount in the femur, so we're going to go backwards in time and figure out based on that how much she should have taken. What we have here are forward calculations, and we go based on if we gave somebody a certain amount. It's the same calculation a doctor uses to determine how much they should prescribe to you to get a certain amount in the blood. That's a forward-based calculation.
So you're saying all he did was say, if this amount were given, then you would have this range?
Correct.
Okay, but that matters only because the prosecutor argued that the femoral blood level was an appropriate level, and therefore it had to be the higher range.
Well, but you know, Dr.
He was effectively, for all practical purposes, he was saying well, he wasn't saying I'm using the 12 to get to a range of 8 pills. I'm saying if you took roughly whatever 8 to 10, whatever the number was, then you'd get a range of 8 to 12 and 8 to 14, and you're arguing the femoral blood was 12, therefore it had to be in that range.
Based on the evidence at trial. Based on the evidence at trial and the evidence from the toxicologist. And, you know, you have to remember here, too, Dr. Arden testified, the defense expert. He agreed that the amount was elevated in the femoral vein, but what he said was, you know what, hey, that's where you take the sample, that's where you get the money. But that isn't what contributed to the death here. What contributed to the death here was the quickly developing and acute pneumonia. So the effective thing that happened here is defense counsel came forward. He went, as I said, to the jugular of the Commonwealth's case, and he attacked cause of death. And, you know, Judge Healy in his decision did a great job in going through and showing the cross-examination and how it was obvious, because what we're talking about here is, did defense counsel investigate this? Well, yes, he did. He had the reports, he had the information, and he investigated it. He decided to use this tactic, and we know that any attorney in hindsight is going to say, geez, you know, I could have used a different tactic. Well, Carolyn used a tactic that was effective but didn't work. He used one that was effective and didn't work.
Say it didn't work. She was convicted of second degree. He was convicted of first degree.
Well, as Judge Healy said in his decision, Michael's behavior was far more atrocious and cruel.
Right. Well, he said the evidence of extreme atrocity and cruelty was greater in his trial than in hers. But I didn't really understand what
I
that
don't
meant,
necessarily.
because her condition was the same, of course, in both trials. I mean, the victims. So the only difference would really be in the first Cunin factor as to whether the defendant was indifferent to or took pleasure in the suffering.
Well, I don't necessarily agree with that. I think they should have both come back as first-degree murders, but I'm not the jury, and I have to agree with the decision of the jury as a good citizen of the United States. But I will say here that Michael and this gets into the argument about some of the so-called bad acts, the motive and the intent. His hostility and his cruelty towards Rebecca was horrific. Pushing this sick child down the hallway, telling her, get the F back to bed, when all she wanted was her parents to help her when she was grievously ill, is just beyond
Right.
the pale. And he's the one that did the pushing and get back to bed. Although one of the first things he told the police was that Carolyn told Rebecca to get back to bed. It was Michael.
But it was Carolyn who gave the pills.
At his direction. Shut her up.
And the evidence of his direction is what?
Is that witnesses in the household said that Michael controlled the medicine, that as soon as Michael said, shut those kids up, she ran, got the clonidine, and gave them whole pills, even though that she was prescribed they were prescribed just half pills. It was at Michael's direction that this happened. And that's one reason it was important to put into evidence the family dynamic here, because going back even to the 4 years, which my brother has claimed is too remote, because without the full explanation of what was going on in this family, there's no way that a jury could understand this. In that light, it's much like the Robideau case. The family that was belonging to the religious cult, and the dad sat by and watched his son deteriorate and die because the elders had said, this is how God will cure him. People had to understand what the dynamic was between the husband and wife and the husband and the 3 children, which was that he intensely disliked his children. He wanted them quiet. He didn't want them around. They were there for money. They were there. That's how he supported himself and Carolyn. And in the aftermath of the murder, essentially said as much, now Carolyn and I have time alone together. We can get our emergency Section 8, and words to those effect. But that's why we went back and why the judge didn't abuse his discretion in allowing that kind of evidence in a trial.
Now, I understand that there was some testimony about the defendant having taken clonidine himself, and he knew what the effects of it were. What use did the prosecutor make of that in his closing?
Well, that was very important evidence because that was part of the intent to kill here, which is that the defendant himself took clonidine, just one wiped him out, and he said that just one wiped Rebecca out. So he completely himself understood the mechanism of clonidine as it acted on somebody, which is that it would just wipe you out. It was a sleeping pill. And anybody knows that if you take enough sleeping pills, you will die. There's no mystery here at all about how Rebecca died. She was just given enough sleeping pills, cold medicine, and in the setting of pneumonia or whatever other illnesses that she had, she died. And she died a terribly cruel and horrific death at the side of her parents' bed. I'm sorry, Judge Botsford.
Well, I thought part of the Commonwealth's, well, it was the Commonwealth's witness, Dr. Vargas, or began with a V?
Dr. Vargas, yes.
That it was a combination of pneumonia and clonidine overdose, but that isn't there some that clonidine can induce pneumonia? Is there something about that?
No.
Okay.
If you are in a very weakened state, pneumonia can come upon you. So clonidine would be the weakened state, and then pneumonia can come upon you. Dr. Vargas said that either would have been enough to kill Rebecca.
Did the pathologist opine that that Rebecca had pneumonia?
The Commonwealth pathologist also saw pneumonia on the slides, but her opinion, the Commonwealth pathologist, her opinion was that the clonidine was the effective, the clonidine and the other medications, which were all sedating, in combination caused her death. Dr. Arden, the defendant's pathologist, said that it was this rapid pneumonia that caused her death, and that although the clonidine was elevated, he couldn't believe that that could possibly cause her death. So that was the state of the evidence as far as that was concerned.
Was there ever a thought of prosecuting the doctor?
It was presented to a grand jury and no billed. And she is still practicing at Tufts. So if there's any other questions, I would respectfully ask that this court affirm this conviction, and I would otherwise rest on my brief.
Thank you, counsel.
Thank you all.
All right.